And it looks like right now we have about 20 questions. So we'll start right up with the questions. The first question is it legal for an HOA member to audio tape the annual and quarterly meetings, even if the HOA is self-governing? So short answer is yes. Take a peek at our cheat sheet that we have on recording board meetings. It's on our website, mulcahylawfirm.com. Under Arizona law, an owner is allowed to audio tape board meetings or annual meetings, quarterly meetings. The only exception would be is if the board passes a rule saying that the board is going to be audio taping the meeting, then and owners are not allowed to, then owners would not be allowed to, but there would have to be a special rule that the board makes under Arizona law. Remember that if the board's audio taping or videotaping the meeting or recording the meeting, that the board has to keep it 6 months, and owners can request an unedited version of that during that 6-month period. Question number 2 from an elected board member. How can the board remain discreet in searching for a new management company? It would not be a good idea to have the current company know of our future plans. This is always kind of a sticky wicket. It's almost like you're cheating on the management company, right? You're not happy with the management company and you're looking. The one thing practice pointer I'm going to give you is that our industry in Arizona is very small. Even though our state has exploded in terms of growth and number of, HOAs and number of units and lots and HOAs, it's still a pretty small community, all things considered. So if your board is searching for a new management company and you're reaching out to other management companies, it's pretty common that whoever you're reaching out to is going to contact your current management company and say, hey, what's this board like? Or why are they looking? Or, and now your current management company is going to know, oh, they're looking. And so, there's a risk that you run if you try to, be quiet about it and not tell your current management company that you're looking. It may get back to them, is my point. And if that happens, then they may terminate the contract quickly, and you may not, that might be surprising to you. You got to act quickly to find a new company. I think there's 2 ways to do it. One way would be just to be honest with them, or 3 ways, actually. Just be honest with them and tell them, hey, we're looking. But recognize if you do that, hey, they're probably going to stop working, because that's just kind of how it works in our industry, that they won't be working as hard if they know they're getting fired, or they may fire you. So honesty is the first one. There are risks with that. The second one would be to, be sneaky and do it behind their back, and ask for confidentiality when you're reaching out to the new management companies that you might be potentially soliciting. You still have to provide notice if a quorum of the board is meeting to discuss business. So you're going to have to do the notices yourself, without the management company helping you with that. Like I said, there's a risk typically that they're going to find out. So be careful with that. The third option is to just let them know that you're doing a price check and we're testing the waters, and that we are going to be asking, for an RFP from you, our current management company. And we're also going to ask for a couple other companies to compare and contrast with, your bid if you choose to submit it. And that way you're being transparent, and you're still giving them an opportunity to bid. And, hey, who knows, maybe they turn it around and they start giving you a lot better service during this time period. So I think those are the good options, in relation to your question. Question number 3, when are the minutes of the annual meeting approved? At the next board meeting or at the next annual meeting? So it's at the next annual meeting. So if you had your 2026 annual meeting in January, you will approve those minutes at the January 2027 annual meeting. The homeowners approve the minutes at the meeting, okay? Is approval of the minutes approval of the actions, or just approval of the minutes as recorded? It's just approval of the minutes as recorded. Okay, question number 4 from a manager. If 2 homeowners are having a dispute, one neighbor's children are throwing bottles, rocks, and other items over the fence and damaging the other owner's property. Is this a police issue or an HOA issue? Homeowner who is having the damage caused to his home wants the HOA to intervene and to stop the damage from occurring on his property. Okay, I think it's kind of a hybrid approach here. So I think the association, if this is occurring and there's evidence, credible evidence that, the neighbor is causing it, I think the association is probably a nuisance under our documents, and the association should send a letter to the offending owner outlining that we've received complaints on this and it needs to stop. In addition, I would tell the complaining owner to also contact the police. I don't know if they'll get involved because it depends on how busy they are that day. But it is something, that the police probably, if they have time, they will knock on that door of the neighbor and, talk with them about it. Hopefully that will make the issue go away. Question number 5 from an owner. If I have requested an appeal and request for a hearing for over a year, it has been ignored and not even acknowledged. They started fining me. Can they fine without being heard or even denying my appeal? So under Arizona law, in order to levy a fine, we have to give notice of the violation and an opportunity to be heard before we levy the fine. So I don't know the facts of your specific circumstance, but it appears that, you weren't given an opportunity to be heard, or maybe there's been a miscommunication. So I would attend a board meeting and talk with the board about this, or write them a letter indicating that you feel you didn't have a right to be heard and you're asking for time with the board. Question number 6, is it legal for an HOA to require your house be painted with a specific brand of paint, such as Dunn Edwards? I don't think it's a matter of whether it's legal or not legal. I think that boards, there's typically architectural approval anytime an association, owner is repainting their home. Okay. They have to get architectural approval from the board or the architectural committee. And so that is legal from the standpoint of the contract. The CC&Rs say you have to get approval. Oftentimes, to make it easier for the owners, what the board will do is they'll say, these are the approved color palettes for the association. And maybe they, had Dunn Edwards come out and do the color schemes for the association. Now, they may say that you have to use Dunn Edwards, barely white or whatever the color is that they pick. You can match that color typically, with a different brand, as long as it's properly matched. You run the risk, though, that if it's not properly matched, you will be in violation, and, they'll be able to pursue their legal remedies against you. So, I would recommend best practices would be use the Dunn Edwards paint that they're suggesting, because that's what you're approved to use. If you, want to be the type of person that wants to challenge it. I don't want to pay for Dunn Edwards paint. I want to use Home Depot or whatever. Just make sure it's matched. You're going to have to buy the Dunn Edwards paint, take it to Home Depot and have them match it. And there's a risk that it may not be exactly the same. And if that's the case, if it was approved as a Dunn Edwards color, it needs to match exactly the Dunn Edwards color. Okay, question number 7. Homeowners in assessment arrears seem to always dodge the process server, even if the cars in the driveway are not pickup certified mail. The process server gets paid regardless of effort and results, and the association is wasting money. Can you describe the next step for obtaining a court order to serve by taping the documents to the door? The property is not vacant, and comment on the usefulness of this practice. So, great question. If we're involved in a lawsuit against an owner, we have to serve the lawsuit personally on whoever the record owners are. And typically we don't have problems with service because, the process servers are smart. They go out to the property on a weeknight and, they're going to go at a time that they think they're going to be able to serve the person. But there are some people who play games. And if that happens, we have to document that the process server has gone out to the property through the process server creates an affidavit of attempted service. And we have to show that this person is actually tied to that property and living there. So, we have to show a judge that through these affidavits. And so having a vehicle parked in the driveway, having the lights on, is showing that the person's home, but they're refusing to answer, that the curtains are moving or whatever. We take all that information to a judge and ask via a motion for alternative service to post the summons and the complaint on their door, and also to mail it to them. Usually we don't mail certified mail unless the judge makes us, because people never pick up the certified mail. And if you just mail it, it'll just go right to their mailbox. But this can be done. It's just by a motion to the court, but it takes a little longer because we have to prove that we tried to serve them in person, and we have to prove that they're tied to that property. And sometimes the judge will say, I don't have enough information. I need you to go back, press the server to go back and give me more information. So it kind of adds like 3 months to the service process if you have a homeowner playing games like that. But it's done pretty regularly. And, it is something that is useful to help us get the owner served. Okay, next question, number 8, from a homeowner who's running for the board. We can amend our CC&Rs by 75% of the members casting votes at a duly called meeting of the members. Does this meeting have to be physical, or can it be by mail and online voting? If you're required to have a meeting of the members, you actually have to have the meeting. You can't just do the whole thing, in writing, only by mail. So you can do it virtually if you want to, but if it says that you have to have, meeting like it apparently does in your documents, you have to notice the meeting, have an agenda, just like an annual meeting, right? Special meeting of the membership. And if you can have people vote by mail-in ballot or absentee ballot or electronic voting, but you also have to give them the right to vote in person at the meeting if they want to. Okay, question number 9. How do you have a quorum when you have no election? 3 people running for 3 openings. Well, even though you have 3 people running for 3 openings, you still have to conduct a meeting, and they're not like automatically just put into office because there's only 3 people running for 3 spots. You still have to go through the whole process of the ballots, counting the ballots, even though it's going to be pretty simple to count them because there's 3 people running for 3 spots. You still have to have a quorum at the annual meeting in order to count those ballots and conduct the meeting. Okay, question number 10. Is there a way to go back and see the first meeting of the year? I'm wondering if you're asking about our first meeting, meaning our first Neighborhood Services Virtual HOA Academy. So yes, there is. We have all of them posted on our website at mulcahylawfirm.com. So anytime we're teaching a class like this, we post the recording of the class. Pretty quickly after the meeting, we do some fine tuning on, we put like an introductory slides on it. And, we post that typically on our website within a week of the class occurring. If you want to see it pronto immediately, you can go to Facebook, Mulcahy Law Firm's Facebook page. And as soon as we log off today, you can go back and look at, the recording of it, which is on Facebook. Okay, next question, number 11. Don't your governing documents specify owners of record on a certain date are allowed to vote? Some do and some don't. Some say for the purpose of, the annual meeting, as of 10 days before the meeting is the record date. And if you are an owner as of 10 days before the annual meeting, you won't be able to vote at the annual meeting. So yes, that is, some documents have that, but not very many. Question number 12, from a board member. Is it required to have a write-in line on the ballot for election of the directors? No, it's not, unless your documents require it, meaning typically it would be in your bylaws. It's something the board should discuss before the annual meeting to determine whether or not you're going to have that on the ballot, whether or not you're going to allow it, and then have the meeting notice indicate and the ballot indicate what your position is on that. Now, again, if it's in your documents, you may have to do it. Okay, question number 13. Our manager said that one person who submitted a request for candidate form did so late, so we cannot vote on that person. The forms actually arrived to the homeowners after the stated due date. Our documents don't address this, so our board is able to appoint a director and vote them in at next year's annual meeting or at our next board meeting. I'm kind of having trouble understanding this. So, okay, one person submitted a request for candidate form. It was late, but I'm also hearing from you that the board sent it out, or the management company sent it out late, so they didn't even get it to them in time. So it sounds like there's, been some poor handling of this by the management company. So you're wondering how to handle this. From my perspective, if the person submitted a request for candidate form, I think they should be listed on the ballot in light of the totality of the circumstances there. You're asking like, can our board appoint a director and vote them in at the next year's annual meeting or at our next board meeting? mean, I don't know where you are in the annual meeting process. Like if somebody submitted their request to be a candidate and you haven't sent out the notice yet, and maybe your annual meeting is still in the works, you might be able to add them and have a ballot with that person's name on it. If the annual meeting already occurred and you didn't add that person to the ballot, that may be somebody you may want to appoint to fill that vacancy. Question number 14, can 2 members of a 3-member board call for a meeting if the 3rd member objects, the 3rd member being the president? Yes, so 25% of the board can call for a meeting. So you are, 66%, you're 2 out of 3, so you should be able to call a meeting of the board. Okay, question number 15 from a board member. If an HOA wants to change lawyers for collections and representation, what does that process look like? Does an HOA have to buy the accounts back from the lawyer, or can they leave the clients at that attorney there and start sending new ones to the new attorney? What is the best practice? This is a great question. Well, first of all, the board is always in charge of selecting who they want to use as their legal counsel or their lawyer. They do not have to use the person that their management company is suggesting, and the management company really shouldn't be requesting or requiring you to use anybody. It's up to the board who you want to hire to be your lawyer, and really you should be hiring somebody who's independent and who is not too closely aligned with the management company. Why? Because if you get in a disagreement with the management company, you want the lawyer to be independent and to be willing to help you and, give you good advice. Okay, so now we're talking about collections and representation. Your association wants to switch lawyers. It sounds like you got into one of these deals with an attorney that, what I call free legal. Our firm does not do this, and we don't do this, and we've never done this in 29 years because I think it is improper, frankly. So there are a number of lawyers and law firms in Arizona that market to HOA board members and HOAs and condo board members that, hey, we'll be your lawyer for free for collections, and we'll do everything for free. And the homeowner will pay all of our legal fees. But the contract says in the fine print, if you ever want to fire us, you have to pay us every penny that we've ever billed. And if you go and look at what they've been billing, there's been no oversight. It's typically much higher than it would be if you were just having a regular lawyer sending you a bill every month for the work that they were doing. And so it puts the board in a really precarious position because if they want to switch lawyers, they really can't because they got to write this big check for 30, 50, 80 grand to buy the accounts back from the lawyer, which to me is just beyond. I can't even imagine doing this to a client. So I think it's problematic from my viewpoint that I have a problem with this practice because a client should always be able to leave whenever they want to without any penalty. So if you're in this situation, have your new attorney look at the agreement that you signed with the free legal lawyer. Typically how we handle it is we just stop giving the free legal anything new and just move over to the new attorney, because what prompts the free legal to charge you is saying you want your files back. And so you're kind of stuck leaving those files with them. And then anything that's new, you should be giving to the new attorney. Okay, question number 16. Can we have an executive session to discuss the job performance of our manager? So short answer would be yes. Question number 17 from an owner's representative. Does Arizona law actually define formal action for purposes of Arizona revised statute? And if it does not, on what legal basis can the term narrowly be confined to motions and votes, particularly given that 33-1248 Arizona revised statutes expressly requires the statute to be construed in favor of open board meetings, and restricting owner input doesn't seem to align? Okay, so Arizona law doesn't officially, in the Condo Act or the Planned Communities Act, define formal action, but it's a very common term. And so formal action is going to be anytime the board votes on an issue at a meeting. So I guess your question is, if a board makes a motion and there's a second, and on a topic, and when the discussion opens, then owners should be allowed to comment before the board takes formal action, which is the next step, voting on it. And so I think it's aligned with the open meeting law, right? It's allowing owners to participate. They're not board members, so they shouldn't be participating throughout the whole meeting, but they should be allowed to give their feedback before the board takes formal action, meaning that there's going to be a vote by the board. Now, if there's only a motion and not a second, then you don't get a chance to participate because it's not moving forward to the discussion stage before a vote. Question number 18, should all homeowners be given a copy of the board packet before a board meeting? No, board packet only goes to the board members. Question 19 from an owner, how do you handle a homeowner whose goal is to disrupt the meeting by yelling, screaming, cussing at the board and other owners? In the past, meetings were adjourned, but then no progress on agenda items or input from other homeowners. Okay, you need to look at our cheat sheet, which is called Dealing with Difficult People and Harassment. It's on our website at mulcahylawfirm.com. Short answer, how do we deal with this particular owner? Announce at the beginning of the meeting rules. If they don't comply with it, kick them out. If they refuse to leave, start having an off-duty police officer or a security guard at your meetings to enforce the rules. If the bad behavior continues, maybe have the attorney write a letter to the owner, outlining that the behavior is inappropriate. Another tip would be to tell them they can attend, but they can only attend on Zoom. That way we can mute them if they're getting, really out of hand. Let the attorney for your association handle this person. And if their harassment is rising to the level that they're making threats of physical harm or actually physically harming you, you may have grounds to get an injunction prohibiting harassment with the local justice court, and they'll have to stay 50 to 100 feet away from you at all times. Okay, question number 20. If you conduct a boot camp for an association, does it need to be an open HOA meeting since all board members will be in attendance? So great question. It doesn't have to be. It can be under the first exception for the executive session meeting law. Advice from your attorney, it would fall under that. So if the board wants to have it in an executive session, which most of the time we do because we're talking about sensitive topics, and I'm there as your legal counsel giving you advice, most boards have it in executive session. If you want to have it in the open session, you certainly can. Question number 21. Do you have an outline for meeting agenda and meeting notes? I'm trying to think if I have one handy. I don't think we have a sample one, but here's what I would say. Go to our cheat sheet on board meetings and look at the meeting minutes, and that will give you a sample of the type of things that are used for board meetings. So that will help you create the agenda by looking at the meeting minutes. Okay, next question, number 22. Can a reserve study be paid from reserve funds, or must it be funded by the operating budget? Oh, that's a really good question. I haven't really thought about that. I think it is, in 99% of the time, I think it's paid out of the operating budget. But I don't think that there's any hard and fast rule on that. I suppose if you wanted to pay it out of the reserve study, an argument, I suppose, could be made for that. I think 99% of the people pay it out of the operating budget. Okay, question number 23. I'm just doing a quick little check to see how many more we have. Next question from an owner. What is considered best practices for handling violations before issuing fines? For example, how many notices or what level of continued noncompliance typically justifies a fine? And based on your experience, what usually causes an issue to escalate to litigation? Is there a general threshold or pattern that you see? Okay, so best practices for handling violations before issuing fines. Send a courtesy reminder note, have the management company send a letter, and then have the attorney send the letter with the fines. We have to set it up, obviously. So it's going to be notice of the violation, opportunity to be heard in writing, and then we levy the fine. So usually it's going to be like the third communication. Maybe you don't use an attorney. Maybe you're self-managed, and maybe you do a friendly reminder, and then another reminder, and then the third one we start fining. It's really up to you. What causes an issue to escalate to litigation? Typically, it's a more serious violation. Could be a health and safety issue. it could just be an ongoing violation that it's just, we're not making any progress with the fines. Typically, I would recommend that you have your attorney suggest, okay, this is something that we should pursue litigation on, or give the different options, go to the ADRE litigation, or what would be some other options that you would have. This would be strategize with your attorney before you ever go to litigation, because litigation is very expensive. Question number 24, can you self-govern your community without a management company? So short answer, yes. Make sure that your documents, your bylaws don't require you to have a management company, but there are many self-managed associations in Arizona. Usually they're smaller, but some are larger, and they have just like an on-site, management company, one person that's there. It just depends. Okay, question number 25 from a board member. Does an in good standing requirement for a board member candidate include being free of unresolved covenant violations? Good question. So it depends on how your documents define in good standing. So I'd have to look at your specific documents to evaluate that. There's not like some hard and fast general rule on this. If your bylaws or your CC&Rs say that a board member has to be in good standing, hopefully it defines what in good standing means. Okay, question number 26. If a homeowner requests to record board meetings who cannot always make the meeting on time on Zoom, does the board have to comply, either by recording meetings or allowing the homeowner to have the meeting recorded? So a homeowner is asking the board, please, can you record the meetings because I can't make it? I mean, if you have a homeowner that's asking that and you're having your meetings on Zoom, I mean, why wouldn't you, right? I think it's a good, transparent thing that you can do, and then other people can come back and listen to it. Most won't, but apparently this homeowner wants it. Do you have to comply? No, you do not have to comply. But the board doesn't have to comply. But if you do video or audio record it, you have to keep it for 6 months and then give the owner an unedited version of it if they ask for it. If the owner is asking, for a third party to record it or something, then we have to fall back on what the law says. An owner is allowed to, record the meeting unless the board has rules that says the board's going to do it. So I would just comply with it. It's always best to get along and, be transparent. Okay, we have 3 more questions. Question number 26. If a homeowner requests to record meeting, I already used 26, so 27. What can be done when a homeowner paints their building without permission and with a color that is not listed? This is just a violation status for this particular owner. At first, I checked the documents to make sure that this is something that they needed approval for, which I'm pretty confident they did. I would send them a letter. I would escalate this to the attorney after the letter. You're going to have to, this is going to be touchy because they spent money and they painted it a color that, isn't approved. Make sure that color, if you have an approved color list, you probably want to check it to make sure that it's actually not an approved color. Talk to the homeowner, see if you can resolve it. If you can't, then you may need to go the legal route and have your attorney get involved. Fining an owner is another option. Litigation, going to the ADRE. These are all different avenues to get the owner to comply. Okay, one way to solve this kind of amicably, which we've seen in the past, is sometimes if it's not that far off, what we'll do is we'll say, well, we'll allow it for this time, but then when you go to repaint it, you got to repaint it approved color. But most of the time, if it's really obviously not, then they have to repaint the home, and either a judge orders them to do it, or they voluntarily do it, or, we do lots of fines. We may even have a self-help provision where we can go in and have the association repaint it and then charge them for it. But again, this is a good opportunity to open the dialogue with the owner and try to work it out. Okay, our last question for today. What is the recourse to an owner who wants to attend committee meetings and or meetings with a particular vendor, such as a reserve study provider? Either could be attended by less than a board quorum. Okay, so if the quorum of the board is meeting with a vendor and it's an open meeting, the homeowner should be allowed to attend. If it's less than a quorum meeting with the vendor, the homeowner doesn't have to be included. Okay, and it would be unusual to have the homeowner be included with the vendor if less than a quorum is meeting with them. We had a great turnout today, 139 viewers at peak, and we had 9 of you here with us on Facebook today. So, really great turnout today, just under 150 owners here for our topic today, which is amazing. We have a couple of classes coming up in the very near future that we want to just give you some information on. So we have our First Fridays, which is our next learning opportunity is going to be on Friday, March 6th. And that is going to be our regular First Fridays where you can just come in virtually and provide questions. You give us questions through our website and we get online and answer questions. That's always the first Friday of the month. And the next one is going to be on Friday, March 6th. We also have a class coming up on the Scottsdale Neighborhood College. I'm sorry, I don't have the topic listed here. Maybe in the future, let's add that to the script for our future classes so that we know I can publicize on this class what the topic's going to be. So our next in-person opportunity to learn, I think it's actually coming up. I think the date's wrong on the script, so I'm not going to even say it. I think it is coming up next week. So, but double check on our website for more information on that. I can probably check real quick too. And that's going to be the Scottsdale class. Let's see here. I'm just going, the easiest way to look always is go to our website at mulcahylawfirm.com. And you just click right when you get to the homepage, you click on upcoming seminars and you'll see everything that we have coming up. And so our Scottsdale Neighborhood College is actually next week on Wednesday, February 25th from 1 to 3 p.m. at the Scottsdale Mustang Library. And we're going to be talking about HOA finances. So we're going to be talking about from budgets, how to create a budget, how to follow the budget, how to amend the budget, how to read a financial statement, to fraud prevention. And that's going to be in person. And the city of Scottsdale is putting that seminar on. So it's next week, next Wednesday, February 25th, from 1 to 3 p.m. at the Mustang Library. If you're interested in attending that, you can sign up on our website at mulcahylawfirm.com. Just go to the upcoming seminars tab. Also, we have our live virtual HOA Condo Academy for March coming up. So we've got the one in-person class next week for Scottsdale, and then we have the first Fridays for March 6th. And then we have our live virtual HOA Academy for March on my favorite day of the year, St. Patrick's Day. And that's March 17th. And that is, we're going to be logging on to Zoom and Facebook Live on St. Patty's Day at 11 a.m. And we're going to be talking about tough conversations and turnaround tactics. So how do we deal with difficult people, dysfunctional boards, and recalls of a board? What are some best practices for recalling a board? So, or if you're a board that's being recalled, how do you handle it? So we are going to have a great topic next month on St. Patty's Day for our neighborhood college. So just in some concluding remarks, thanks everybody for being here today. It's been a great class. I look forward to seeing you in March for First Fridays or our live virtual HOA Condo Academy. Or if you're attending our class in person next week at the Scottsdale Neighborhood College on Wednesday, February 25th. Have a great rest of February and look forward to seeing you again soon. Take care.